welcome to DJure. In this video, we are going to continue the series of labor law important MCQs. This is part 3 of the video. Let's get started. In this video, we are going to mostly cover important MCQs of Industrial Disputes Act. Let's get started. Question number 1. In which year did the Industrial Disputes Act come into operation? So it came into operation in 1947. Option A. Next question. Before the Industrial Disputes Act was implemented in the year 1947, which act took care of the industrial disputes? So before this act, the previous act was Trade Disputes Act 1929. Next question. The bill passing Rule 81A has made 2 new institutions for the prevention and settlement of industrial disputes. That is, the Work Committee and Industrial Tribunal has come into being. Next question. Objective of this Industrial Disputes Act. The objective of this is to prevent illegal strikes, yes. To promote measures for securing and preserving good relations between the employers and the employees, of course. And to provide relief to workmen in matters of layoffs, retrenchment, wrongful dismissals. So the answer would be all of the above. All 3 are the objectives of Industrial Disputes Act. Next question. Power has been given to whom to require works committee to be constituted in every industrial establishment employing 100 workmen or more. So this power has been granted to the appropriate government. Next question. Which permanent settlement machinery has been mentioned in the act accountable for the speedy and amicable settlement of industrial disputes? So this has been given to conciliation officer. Next question. A person shall not be appointed as the presiding officer of a labor court unless he has been the presiding officer under any provisional or state act for not less than how many years? For not less than 5 years. Next question. How many persons shall a national tribunal consist of which is to be appointed by the central government? So the answer to this would be 1 only. Next question. Which section in the Industrial Disputes Act discusses about the qualifications of the presiding officers of labor courts? It is given in section 7C, that is option A. Next question. What are the duties of a conciliation officer as per section 12 of this act? So the duties are all of the above. Please read them. Pause the video and read the duties. Next question. Which section of the Industrial Disputes Act is dealing with the voluntary reference of disputes to arbitration? So the section for this is section 10A. Next question. Labor Code adjudicates the disputes of which schedule? Schedule 2 of the Act. Next question. A labor court shall consist of 1 person which has been a district judge or additional district judge for a period of not less than how many years? Obviously option A, 3 years. Next question. State the triple test as laid down in the case of Bangalore water supply. This is a very important case. Please study this case for labor law, especially in industrial disputes. So the answer for this is all of the above. Next question. Is profit motive necessary for an undertaking to be an industry? No, it is not. Next question. Can a workman approach the labor court directly in such a scenario, or does he have to get a reference from the appropriate government? So the answer is the workman can approach the labor court directly after the expiry of how many days? 45 days after he has made an application to the conciliation officer. Next question. When was this amendment made to section 2A? The amendment of this was made in the year 2010. What is the scope of the phrase any person in the definition of industrial dispute? An industrial dispute can be raised only in regard to any person in whose employment or non-employment the workmen have as a class a real and substantial interest. This was laid down in the case of workmen Dimakuchi Tea Estate versus Management Dimakuchi. In this case, this was a case relating to industry about direct and sub-interest in business, and it talks about the existing relationship between the employer and the employee. So this is an important case of industrial dispute. You can read a gist about this case, and in this case it was laid down the phrase any person. which is important for its definition, so you can read it. Next question, who is a workman? According to option A, according to section 2S, workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, or clerical or supervising work for hire or reward. Here the key word that you have to remember is it is done for hire or reward. So workman does any work which is for hire or for reward. Second, whether the terms of employment be express or implied and for the purpose of any proceeding under this act in relation to an industrial dispute includes any such person who has been dismissed, discharged, or retrenched in connection with. And thirdly, or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute. So these are firstly option A general, second option B conditional, option C exemption. So this is who a workman is. This is basically you can learn the words. It is disputed, terms of employment is not direct, and the person is working for reward. You can just understand the keywords and you can memorize the definition of the workman. So the answer would be all of the above in this case. Next question, can a person in supervisory role be a workman? Yes, the person in a supervisory role can be a workman, provided that he draws less than 10,000 per mensum. Mensum here is month. So if a person draws less than 10,000 per month, then the person can be a workman, even if he is in a supervisory role. Next question, what is a contract for services? So a contract for services is a client independent contractor relationship. Employer here exercises a lesser degree of control, and he can also dictate what to do but not how to do it. So these are three conditions for a contract for services. So answer would be option D, all of the above. Next question, what is a contract of service? In a contract of service, the different parties, here there is a employer-employee relationship. Secondly, the employer exercises a greater control, degree of control over the employee, and he can only dictate what to do, but not just what to do, but also how to do it. That was not the case in the previous one. So you can understand the difference for contract for services and contract of service. The keyword is for or of services. Answer in both the cases will be all of the above. So you can understand, make a definition and memorize it. Next question. Question number 23. Are teachers workmen? So answer would be no, and this was held in the case of Sundarambal versus Government of Goa, Daman and Diu. Next question. Is a university or an educational institution an industry? आंसर वुड बी येस. बैंगलोर वाटर सप्लाई केस में बताया गया था कि येस, अ यूनिवर्सिटी और एजुकेशनल इंस्टीट्यूशन, दे आर इंक्लूडेड इन द डेफिनेशन ऑफ एन इंडस्ट्री. नेक्स्ट क्वेश्चन, बैंगलोर वाटर सप्लाई केस was decided in which year and what was the strength of the bench? So this case was decided on 21st February 1978. It was a 7-judge bench. This is a very important case, as I stated previously also. You have to compile all the details of the case and just understand its gist. Industrial disputes, which is the most important case. Okay guys, we are done with the video. These are 25 most important MCQs of labor law part 3. Stay tuned for part 4. Thanks for watching. De jure.